Arbitration in the shadow of power. Why Lockean rules only exist because the state enforces them. Arbitration does not emerge from moral commitment, legal philosophy, or abstract respect for rules. It emerges from expectations. More specifically, arbitration arises from each party's expectation about what outcome will ultimately be enforced if voluntary agreement fails. Once this is understood, both the structure of modern arbitration and its likely evolution in a purely market-based system become clear. In contemporary legal systems, arbitration is shaped by the shadow of government enforcement. Parties agree to arbitrate not because they intrinsically value arbitration itself, nor because they are philosophically committed to any particular legal doctrine, but because they anticipate that unresolved disputes will ultimately be decided and enforced by courts. These courts operate within a framework heavily influenced by Lockean property norms, first possession, voluntary transfer, and contractual obligation. As a result, parties form expectations about how a court would rule and then arbitrate in a way that maximizes their expected payoff within that legal structure. This is the critical mechanism. Arbitration today is a profit-maximizing strategy under a known enforcement regime. If two parties expect that a court will award property to a particular claimant based on Lockean principles, they will negotiate and arbitrate in advance to avoid the costs of litigation, aligning their agreement with that expected judgment. Arbitration, therefore, is not independent of the state, it is downstream from it. It is a rational response to the anticipated behavior of a centralized enforcer. This insight exposes a fundamental weakness in the anarcho-capitalist claim that arbitration can be sustained through pre-agreed adherence to libertarian or Lockean rules, independent of government. Thinkers such as Robert P. Murphy argue that individuals would voluntarily agree, in advance, to arbitrate disputes according to certain legal principles. However, this framework is subject to adverse selection. Parties will only agree to such rules when they expect those rules to favor them in potential disputes. If a party anticipates that Lockean principles, such as strong protection of initial ownership, will disadvantage them relative to another claimant with greater productive capacity, they have no incentive to bind themselves to those rules. As a result, pre-agreed arbitration systems based on fixed legal doctrines lack stability. They are not neutral mechanisms, but strategically selected tools. Different parties will prefer different rule systems depending on their expected position in future disputes, leading to fragmentation and selective participation. There is no guarantee that a single coherent legal framework will persist, because the incentives to adopt or reject any given framework are endogenous to the distribution of expected gains and losses. Once government enforcement is removed, the foundation of arbitration necessarily shifts. Without a centralized authority imposing outcomes based on predefined legal rules, the question becomes, what determines which agreements are honored and which outcomes prevail? The answer again lies in expectations, specifically expectations about enforcement capability. In a purely market-based system, enforcement is not guaranteed by law but must be carried out through resources, coordination, and strategic advantage. Under such conditions, the expected outcome of a dispute is determined by each party's ability to credibly impose costs and sustain conflict. This naturally leads to a different arbitration equilibrium. Rather than arbitrating based on fixed legal doctrines, parties will arbitrate based on expected profit and loss. More precisely, they will engage in bargaining processes analogous to Coasian negotiation, where the goal is to allocate resources to the party that can generate the highest net value, while compensating others when efficient. The anticipated enforcement outcome becomes a function of comparative advantage. The party who can utilize the resource more productively can justify greater expenditure in securing and defending it, and therefore has an enforcement advantage. This creates a powerful stabilizing mechanism. If one party can generate greater value from a resource, they can afford to outbid or outcompete others in both negotiation and conflict. The opposing party, recognizing this, has an incentive to settle rather than incur losses in a contest they are unlikely to win. Arbitration, in this context, becomes a tool for realizing gains from trade under the shadow of competitive enforcement rather than legal decree. Importantly, this system avoids the adverse selection problem inherent in pre-agreed rule-based arbitration. The rule is not an externally imposed doctrine, but an emergent equilibrium. Resources tend toward their highest value use because that is where enforcement power concentrates. Arbitration aligns with this outcome because both parties expect it to. Agreements are formed not because of ideological commitment to a legal system, but because deviation from efficient allocation is costly and unstable. In this sense, arbitration remains fundamentally expectation-driven across both systems, but the content of those expectations changes. Under government, expectations are anchored to legal rules and judicial enforcement. Under a pure market system, expectations are anchored to economic realities, comparative advantage, opportunity cost, and the distribution of productive capacity. The deeper implication is that arbitration is never truly about law. It is about the anticipated endpoint of conflict. Legal systems merely formalize and stabilize those expectations in one way. Markets, under different constraints, generate their own equilibrium expectations through profit and loss. Thus, the transition from government-backed arbitration to market-based arbitration is not a transition from order to chaos, but from one expectation regime to another. The former is grounded in legal formalism, the latter in economic selection. And in both cases, it is not rules that ultimately govern outcomes, but the expectations of those who must live with them.